Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Each Friday morning at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select Resources, then select eDiscovery Leaders Live. My guest this week is Beth Thomas. Beth is the Director of Litigation Technology and Support at Becker and Poliakoff. She has over 30 years of experience as a litigation paralegal specializing in evidence collection, organization, analysis, and procedures for use and admissions at trial and mediation. She has extensive trial experience in both federal and state courts. At the firm, she's led the introduction and implementation of the firm's uniform case management system for all litigation matters. Who doesn't want that type of uniformity? Including both physical file structure and electronic case management. She created the firm's litigation support department for collecting, processing, and organizing all case evidence, and manages the firm's litigation paralegal team. Beth is a Florida registered paralegal, having graduated in 1983 from Becker University, where she obtained her certificate as a paralegal. Beth, welcome.
Hi, George. Thank you.
Hi, glad to have you here with us today.
Nice to be here. Thank you.
Yeah, I'd like to start by expanding a little bit on that quick introduction I gave, and have you talk about just a broad overview to provide our listeners, viewers with context, what you do, where you are, and what where you are is.
Well, I've been with Becker for 20 years, and I started with Becker as a paralegal. However, I had already had experience in my prior firms with case management, collecting evidence. Of course, evidence collecting was very different back in those days. And so coming into Becker, we implemented some systems for case management and collection on a physical paper type case management. And we've evolved with technology into the electronic case management system. One of the things that we promote in the firm and that I continue to work with is educating the staff, educating the attorneys. We're very team oriented. So we want to make sure that everything that we do in our cases, office by office, is uniform. And so that way, when a case comes in, you start working on it in Fort Lauderdale, and 5 years later, you're ready for trial. You can pull in assistance from attorneys and paralegals from other offices. They step right in and they can find witness files, witness information, evidence information in the same location and manner in which they maintain their files. And so that was a big role for me, was implementing that system and continuing the education in that system. In addition, I also oversee the litigation support staff. We have an internal litigation support department, very similar to protocols in documenting the intake of evidence and defensibility of evidence that you would work with an outside service provider. We do in-house, and the tracking of that, working very closely with our attorneys and paralegals. And then with the litigation managing partners as a whole and the practice group as a whole, I also provide support to all the litigators when it comes to best practices for either case management, e-discovery, trial preparation, and sometimes sitting in the hot seat in the courtroom. So,
well, you have a lot of hats to wear.
yes.
How do you manage to juggle all of that?
It's a lot of hours, and sometimes when you love what you do and you have respect and admiration for the individuals that you do it for, it doesn't seem like a job. It's something. It's family, and we do it for our clients. We do it for our attorneys, and I enjoy that. So, and if you don't love litigation and thrive on being constantly pulled in all directions and being able to handle that, then you don't belong in litigation. And so, thriving on that type of caseload is what we do.
Yes, but I mean, I remember 2, 3, 4, 7 different teams, litigation teams, all thinking their lawsuit is the most important matter being handled by the firm at the time, each feeling as if they need attention right away now. We've got a hearing tomorrow. We've got a trial starting next week. We need to get this production out. You can't do all of them all at once. How do you make that work out?
Well, that goes back to the team approach and the fact that our cases are uniform. And then we can pull from all resources. We help each other out between the litigation support staff, the paralegal staff, and I'm going to correct actually that information on managing the paralegals. I no longer do that. I do have a wonderful paralegal manager that works side by side with me, and that's taken a lot off, and I've been able to focus a little bit more on the litigation support end. So that has changed over the years. And so working with our litigation paralegal manager and directly with the paralegals and the attorneys, we managed to juggle. And after all these years working with attorneys, you learn to know which ones are really crying, I want this, or I need this, or I must have this to meet some court order or, time frame. So, a lot of times it's a matter of we will never tell you no. We will get you what you need. Just work with us on timing. And so a lot of times that's how we juggle.
You've mentioned a couple times now the uniform approach, and I'm sure you've heard, I know I've heard, I've probably been guilty of saying that every lawsuit is unique and not like any others. And yet we know, of course, that's not true. What have you put together to help with the uniform handling of these cases that the attorneys often think are unique, special, and unlike anything else?
Mm-hmm. Well, we do know it's not a one size fits all. The legal field is not one size fits all. Cases are not one size fits all. But one of the things that we are very proud of is the fact that when we have a new matter come in, no matter the case size, we approach the case management of that matter, whether it's going to be settled in 3 months, or if we look at it as, a 2 million, 3 million record case that's going to go on for 5 years, we treat them the same. And we've pride ourselves on training our staff, including all the way to file clerks, on intake work, who's responsible for what. The attorneys have their role, paralegals have their role, the legal assistants have their role, and we work cohesively as a team and reach out to each other and communicate what needs to get done. And we do it the same way. And so that goes in every office. We've implemented this case management system where from case inception through trial, every case is handled the same. We educate our staff, so not just telling them, put this in a witness file, but we explain to them, put this in the witness file because later we may need to do this. And so we want them to understand and feel part of that team not just that we're telling them what to do, but understand how we're going to use it as professionals in the courtroom later. And that gives them a sense of being part of the team. And that's one component. The additional component is once we intake evidence, whether it's oral testimony, client documents, production, we have procedures in place where they get imported into a data review platform. Once they're in there, we train the paralegals how to review uniformly, how to code uniformly. And then that way, when we're pulling in other team members to do a massive review, it's uniform in how they're batching them and coding them. So later, when as the attorney team or paralegal team goes in to see the results of that review, all the results of those searches come up the same. We don't have inefficiencies in the manner in which they've been coded. And so that helps us down the line when we want to pitch in and help out another team member. So
how uniformly is your uniform system used? Is it, I'll make up some numbers. Is this something that gets used in 10% of the cases, 90% of the cases, by 10% of the lawyers, 90% of the lawyers? What's it look like?
I'm going to say 98%. We have 98% of our cases are uniform. And we spend a lot of time educating new members that come into the firm, new attorneys. And that's another part of my role, is doing the onboarding process, introducing our systems to new attorneys, new paralegals, new litigation legal assistants, and again, educating them on the processes and why we do them, why certain information is maintained in a witness folder right off the bat so that we can find it later. We all know we don't want to go back to a client and ask him to provide something to us the third time. It just doesn't make us look good. And so by following these protocols, we have everything in the location that we're all used to finding them. And so that's really educating. And then not only initially when they join the firm, but refresher courses. I often travel around, pandemic exception, travel around to the different offices and meet with our litigation teams and refresh them on why things change. We have new, and that's one of the things we promote as well. We have new people come in and they say, well, at my firm, I did it this way. Great. Bring on those ideas to us because we're not perfect. And we want to tweak and make sure that the manner in which we're doing it, because everything changes, that, we're open to new ideas. So
I think back to when I got out of law school, showed up at the first law firm I was at, and they said to my incoming class something along the lines of, you all went to great law schools, whether we did or not. You all got great grades, whether we did or not. We're sure you think you know what to do, but you don't have a clue. None of you know how to try cases. So we are now going to teach you how to handle lawsuits from the onset through the final resolution. I think that's not done so much anymore these days in law firms. What I'm hearing you say is that is done very much so at your firm.
It is. And I attribute this to our managing partners and their desire to educate attorneys when they come into the firm. My desire is the staff and the support so that the attorneys get what they need. But yes, we are very instrumental in training of attorneys, and we actually have a training program that we call Becker and Poliakoff University, where we train the attorneys on skill sets every year, and they actually learn the skill sets, learn techniques of how to apply those skill sets, similar to cross-examining an expert witness or a rebuttal witness. And then we actually have mock courtrooms that we set up so that they can apply these skill sets that they're learning. And so that in of itself shows that our managing partners are really instrumental in educating our attorneys, and we want to educate them to be with the firm for longevity purposes. We want them to grow with our firm and make our firm better.
Right, because if you did not have support from the very top in the firm, this type of educational program wouldn't be happening, would it?
No, it would not. And I tribute my partners for that, because they are 100% both educating the attorneys, but also providing the staff and the litigation support staff with the tools that they need to successfully represent our clients and our attorneys.
So as those attorneys come in, whether they are new hires right out of law school or clerkships, or I assume you have lateral hires as well, right, what do they learn about e-discovery?
Oh, well, that's my role, really, is to let them know that the practices and workflow that we have in place, that's where we touch again with e-discovery on consistency and uniformity. And so we introduce them. Usually every case in our firm has a paralegal assigned. That paralegal has intricate knowledge on the evidence of the case. They're involved in the intake. They work directly with the clients and the attorneys. And so usually we'll sit down and go over any cases that they start working on when they join the firm, and educate them on where we are, what records we have, the manner in which we have collected those records, how we document the source of those records. And the key element of documenting that source is so that we are preparing our case if we went to trial tomorrow. So if we wanted to admit any piece of that evidence in court tomorrow, we would know what witness we would use to authenticate it and lay the foundation and get that in front of that jury. And so we go through that process with the attorneys and teach them about that. It's a multiple part process because it depends on their knowledge. If they understand what a native file is, wonderful. If they don't, we have to start from scratch. And so and then, again, we've spoken about this. We have old school attorneys that want paper. And so we don't tell them no, we just work with them and educate them as we're going along.
Probably not so much for those old school attorneys. This probably won't apply to them or for them, but for the, if you will, more modern attorneys, what sort of training and experience do they get with using the tools you have available? Or is it a situation where they are going to rely upon, for example, a paralegal to actually accomplish the various e-discovery tasks that need to be done?
Well, it depends on the case. It depends on the record set. Is it a set of client records that requires review for privilege and responsiveness? Is it such a large set that we need a first tier review by other parties before the attorney's review? So it's not one size fits all. But if the attorneys are technology efficient and they want to get into the platform and start reviewing, they meet with me. We go through the workflow. We go through, this is the record set we received. This is the best tool and the most cost-effective tool for you to do your review. There may be tools which we have recently added and that actually have AI and predictive coding. And so we educate them on that. And I do that. I sit and educate them on that. I want them to have the best benefit of the tools that we have for the record set that they are trying to get through and be the most cost effective for the client at the same time. If the attorneys come in with e-discovery knowledge from either another firm or classes that they perhaps have attended previously, would love to see that in all the law schools across the country. If they come in with that basic knowledge, it's really does my job for me. And then it's just a matter of acclimating them to the facts and the issues in the case at hand, and then the best way to manipulate and get into that data. So
one of the things you mentioned is that at least some of the attorneys are using some AI capabilities. What are they using? What are they doing with those capabilities?
Well, we have a large construction practice group, litigation. Those are the records that come in that really have unique issues that we can go in and utilize the AI tools to narrow down and cull down for us a significant relevant set of records for eyes on. And so that's where we sit down, we go through the different issues, the different search criteria, the significant custodians, and then we let the machine do the rest. And that's a new tool for us. In the past, we've utilized outsourced third-party vendors for this, where we've utilized their project managers to help us with that and work with us, where now we are doing that in-house. And our clients are reaping the benefit of us having it in-house and that one-on-one attention that they're getting from our attorneys. But so yes, that's what we're doing. We're running the tools, running the software, and letting the attorneys then go in and determine, is this the record set that I need, or do we need to go back and fine tune some of our criteria?
Yeah, construction matters seem to be their own special type of beast, don't they?
They are. I have a whole nother topic on construction litigation and experts in construction litigation and the manner in which they maintain their files and how we need to improve on that. So
yeah, I didn't work on that many construction matters, certainly not enough to consider myself a construction lawyer. And there are definitely folks out there who are that. On the ones I have worked on, either as an attorney or consultant or expert witness, often a meaningful portion of the data that needs to be contended with consists of pictures, photographs, diagrams, blueprints, all of that. Is that part of what you have to contend with as well?
Oh, thousands and thousands and thousands of photographs. And unfortunately, the collections don't always encompass any information other than an object name, which may be a number. It doesn't, when we extract that metadata and on ingestion, we may get a date, but then it's up to us to then go back and try to identify the individual who took those photographs, where, when, why, so that, again, we can lay our foundation for admitting those photographs in trial. And utilizing, now we have a tool that we're actually able to utilize to review those images and identify subject matter within those images, which we're very happy to have. So looking forward to putting that in play so that we don't have to review those hundreds of thousands of email or photographs eyes on, one by one.
Right. It's, definitely a challenge. I did so Bill Hamilton, whom you know, and I taught a course in January on AI and litigation strategies. And dealing with pictures was part of what we covered, image labeling, using AI for that. And we did, on the spur of the moment, a fun little exercise for them. Someone had pointed to me to a blog post from a couple of years back where someone had pulled together a collection of 16 pictures. 8 of them were chihuahuas. 8 of them were muffins.
Oh, no.
And the test, the challenge this person posed was, how well do AI systems do in figuring out which picture is a chihuahua, which is a muffin? I know I wouldn't have gotten it perfect if I'd looked at them, because at least one of those I wouldn't have identified as either a chihuahua or a muffin. I'd have said, oh, that, if anything, that's a chocolate chip cookie. I'd come close, but I wouldn't have nailed it. that must be the type of challenge you're facing with photographs.
It is. And, you can only look at so many photographs of a roof from so many different angles before your head's spinning and you're not quite sure what the photographer was focusing on without the aid of that photographer. And so that's where AI at least provides you with a narrowed down set of records. And these are all the roof. Now it's up to you to get in there and try to identify what it was that this expert or this employee was up on that roof trying to show you. So
yeah, as an attorney, I tried to make sure that unless it really wasn't practical, I never asked people working on matters to do something that I hadn't at least tried to do myself. I had review teams. Therefore, I figured
Sure.
I'd see how I am as a reviewer. And this is going to return back to your point. I was terrible. I was just terrible. After the first 30 minutes, my attention would flag, my mind would wander. I'd start thinking about how things might fit into the case instead of whether they met the criteria I was supposed to be taken care of. And
exactly,
at least metaphorically, after 90 minutes, I would glaze over and then fall sideways off my chair, landing comatose on the floor. And that was with text. With the types of photographs you're talking about, it only has to be even worse. So you've got some capabilities that you're starting to use, the image tagging.
Yes.
Any others that you're teeing up for your attorneys?
Well, the ingestion of emails has always been an issue with prior platforms, whether it was third-party providers providing that or what tools that we utilized in-house. And email threading was always an issue where we would go through and have a paralegal team review and try to cull down to significant emails. But without that threading and that top level ability to only look at the top level email, and then depending on how you want to treat that email, treat the rest of that exact thread, we have that ability now. And so, there's software that we're now training our attorneys on and training our staff on so that they know, the paralegal staff, that they know they can go in and cull down that set. And instead of 2,000 emails, the attorneys are looking at 200, but yet at the same time, we're identifying for the specific tagging will be applied to the entire 2,000. And that's significant. The amount of time that is going to reduce for eyes on review is extremely important to cost effectiveness that's being applied for the client.
Well, it sounds as if not only have you put a lot of time and energy in the past into developing a consistently applied, well thought out system that attorneys across the firm are going to be using to handle cases and making sure they're making the best use of paralegals, lit support, and the like. It sounds like you're also really upping your game in terms of what you're able to do with the technology now available. Doing this, I guess, is my advertisement for you, whatever. getting the most benefit and
sure
cost effectiveness for your clients out of all of this.
Of course. And one of the things that we would love to see, and I personally would love to see, is we talked about review platforms not being one size fits all, but I think in this day and age, with technology, that's all you're collecting from, basically, is technology, some form of technological platform that everyone uses in their everyday life. And so the smallest case coming in, and we run the gamut of the types of matters that we handle, but it doesn't mean that client that just has a small issue with a contract isn't just as important to us as these construction defect cases. Right. And so that small case comes in, we utilize our platform from case inception through trial. And so those same records, in my eyes, having all the evidence, all the oral testimony as well, ingested into the same platform, running searches, not just on what you've collected, but then having identified what has been produced. So you know those are the significant records and evidence you're relying on throughout the case. And every record having a history of how it's been treated through the life of the litigation in one place means that you're utilizing that platform for that record from inception, who it came from, who it was produced to, when, and in response to what depot it was used for as a depot exhibit, what motion it was attached to as a significant motion. If you identify it as a trial exhibit, it gets identified within the same platform. And then what witness at trial it's used for to admit it into evidence. Your whole history of that record is in one location. And I see that being the future for litigation e-discovery platforms, not just to review records, produce them, and you're done with that litigation platform. Use it to your benefit for the life of the litigation. And that's how we practice.
It sounds like not just a wonderful aspiration, but a process you actually largely have in place already.
We do.
Beth, our half hour has flown by quickly. Thank you for joining us today. Beth Thomas is the Director of Litigation Technology and Support at Becker and Poliakoff. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Thank you all for joining us today, and please join us again next Friday for another episode of eDiscovery Leaders Live. Beth, thanks so much.
Thanks so much, George. Enjoy your day.
You too.